This is Nick Rabinowitz at the Air Resources Board. We're just going to wait a couple more minutes in case additional folks walk in and to make sure the webcast is working properly, and then we'll go ahead and get started. Thanks. Am I on here? Yeah. Let's go ahead and get started. Thank you all for joining us today in our absurdly large hearing room. I think we have about 4 people in the audience here for a room that's built for our full-size board hearings. But we're excited to start the process of updating the Certified Regulatory Program for the California Air Resources Board, or CARB, as we commonly call ourselves. This will help make our process clearer and more transparent for all our stakeholders. Before we begin, we have a couple of housekeeping announcements we need to make. For safety reasons, please note the emergency exits to the rear of the room. In the event of a fire alarm, we are required to evacuate this room immediately and go down the stairs and out of the building. When we're given the all clear signal, we'll be allowed to come back and resume the workshop. Also, restrooms are out the door to the back and to your left. We are also webcasting today. For those joining us by webcast, you'll see an email address at the bottom of your screen that you can submit questions to. In today's workshop, we'll cover the following topics. What is a CRP? Background on CARB's CRP. What is CARB currently proposing in terms of the amendments to its CRP? The benefits of CARB's proposal. Next steps, and a request for public input. So what is CEQA? Very briefly, for anyone who may be unfamiliar with this area of law, CEQA, which is short for the California Environmental Quality Act, is a state law enacted in 1970 which requires agencies considering discretionary project approvals to analyze the potential environmental impacts from their actions before they approve them. CEQA is a largely procedural law that involves impact analysis and disclosure, public review and input, considering project alternatives, and mitigating or avoiding any significant environmental effects to the extent feasible. While the actions undertaken by CARB are for the purpose of protecting air quality and helping combat climate change, the Air Resources Board is also still subject to CEQA like all public agencies in California. This means before taking a discretionary action, The Air Resources Board must consider the reasonably foreseeable direct and indirect environmental impacts that could result from its proposed action. What is a certified regulatory program? A CRP is a CEQA equivalent process that is available to certain state agencies, which is used by those agencies in lieu of traditional CEQA review. The requirements of each CRP are specific to each agency that has one. Essentially, the CRP serves as each agency's individual CEQA guidelines. Many agencies have them, including the California Energy Commission, the California Department of Fish and Wildlife, Coastal Commission, Water Board, and other state agencies, obviously including CARB. To give some background on CARB's CRP, it was originally adopted in 1978 and was last amended almost 40 years ago, in 1981. As you all know, styles have changed a lot since then. CEQA law has also advanced significantly since then, as have CARB's statutory duties. When it was last amended in 1981, one of the main priorities was trimming down the length of CARB's CRP. As a result, while it's short and easy to read, it could benefit from more in-depth explanation and general updating. So what are we proposing? The regulatory text is still in the drafting phase, but CARB has some ideas about aspects of its CRP that it would like to update and clarify. Overall, CARB's goal is to align with general current CEQA requirements. CARB also would like to more clearly set forth its existing CEQA practices, which have been shaped over the years by evolving statutory, regulatory, and case law developments. In terms of specific areas we hope to address, we'd like to clarify how CARB's public notices are prepared and sent, including notices of completion and notices of determination. Our communications have changed dramatically since 1981, and we will propose to update the regulation to reflect that, consistent with general CEQA law. For example, we plan to expressly state that public notices can be sent via email listserv. We also plan to describe in more detail how CARB files its notices when it's required to do so with other entities, like the Resources Agency. We plan to also clarify our process for reviewing CEQA-exempt projects, including reaffirming the existing law that CEQA's general exemptions can also apply to CARB. We also plan to describe some common CARB actions that typically qualify for CEQA exemptions, such as grants for electric vehicle chargers and updates to certification procedures that CARB administers. We also plan to specify some CARB activities that do not constitute a project subject to CEQA, such as proposals for legislation, continuing administrative or maintenance activities, and approval of funding guidelines where other agencies are responsible for selecting the projects that are funded. CARB further proposes to add more detail regarding the three primary types of CARB environmental review. These levels essentially align with the three traditional levels of CEQA review, which should be very familiar to those of you who have CEQA experience. The first tier is what we call impact environmental analyses, which are roughly equivalent to environmental impact reports, or EIRs. The second tier is no impact environmental analyses, which are roughly equivalent to a negative declaration or mitigated negative declaration. And the third tier is exemptions, which are essentially the same as general CEQA exemptions. We also plan to add some provisions addressing when addendums are used. CARB also plans to align its response to comment provisions with traditional CEQA principles. For example, written public comments are due during the notice comment period. Written comments submitted outside that period are considered untimely and need not be responded to, although CARB may do so if it so chooses. CARB also plans to clarify the intersection between the Administrative Procedure Act, or APA, and CEQA for situations where both of those laws apply to the same proceeding, as is often the case in our rulemaking proceedings here. This would help clarify that, for example, CARB's board can approve a project in its environmental document while delegating to the executive officer the authority to carry out 15-day regulatory changes under the APA and finalize administrative aspects of submitting the regulation to the Office of Administrative Law. So long as the 15-day changes would not result in any significant new information as that's defined under CEQA, The APA process could be completed by the executive officer. If a proposed change would constitute significant new information as defined by CEQA, additional CEQA review would be needed, and the item would be reconsidered by CARB's board at a subsequent board meeting. So what are some benefits of amending CARB's CRP? Why are we doing this? A primary benefit is that it will help provide structure and certainty to CARB's CEQA processes while ensuring environmental protection and better alignment with current CEQA principles. These amendments will also provide greater transparency and certainty for both stakeholders and CARB. They will provide improved alignment with current CEQA principles. Oh, I guess I already mentioned that one. And they will help improve efficiency in CARB's proceedings. These proposed amendments themselves would have no potential to cause any environmental impacts, since CARB's proposal only involves administrative changes to CARB's CRP process to align with general CEQA concepts. The next steps in this proceeding are, in early 2019, CARB plans to release the draft regulatory amendments and initial statement of reasons, or staff report, for 45 days of public review pursuant to the Administrative Procedure Act. In spring 2019, we will plan to present this item to our board for consideration and potential adoption. Finally, we want to hear from you. Please submit any comments or suggestions you have, the comments you have today, you can submit to the email address that's provided with this webcast for the folks that are on the line. But after this meeting and moving forward, you can submit any comments or suggestions to Rebecca Fancher, who's here to my right, at rebecca.fancher@arb.ca.gov. If you have any questions, you can also reach her via telephone at 916-324-1550. And I realized I totally forgot to introduce myself and Rebecca before I started this meeting. I am Nick Rabinowicz. I'm one of the lawyers in our legal office here, and I handle a lot of our CEQA duties. And to my right is Rebecca Fancher, who's the head of our CEQA unit here at ARB, who handles a lot of the day-to-day work we do on CEQA as well. So that concludes our presentation. We will now open the floor to any questions or comments from our attendees, and both those who are here today and those participating via the webcast. So any questions out there or comments? Yes.
Hi, thank you. John Costantino, Tradesmen's Advisors. I represent folks that deal with the regulatory process here at ARB. Question, so I get that you're trying to minimize the number of 2 board meeting items. That's what it sounds like. How will the regulation specify which items will be decided to be a 1 board meeting item or a 2 board meeting item?
That's a good question. I don't think the intent is to reduce the number of 2 board meeting items. I think it would basically, the intent is to more clearly state in the regulation what we're already doing. So, you know, a lot of our regulation actions and planning actions will still involve 2 board hearings. So it's basically going to preserve the status quo of what we're doing, with the intent being to write down more of that into the regulation text itself. To the extent you're asking how we make the decision about which items are 1 board hearing and which items are 2 board hearings, typically the projects we do that involve a full environmental analysis, which is the EIR equivalent level of review, will have 2 board hearings. And so that's the primary reason. There are also other reasons, like if the board requests us to bring it back to the board or something like that, or other staff level decisions could result in 2 board hearings as well. But that's the primary breakdown about how the CEQA unit decides whether there will be 1 or 2 board hearings for an item.
So just to follow up on that and follow up on what you said earlier, where this revised certified program will allow delegation to the executive officer for 15-day changes, does that mean you wouldn't need, how does that change the sort of process? Because as it goes now, it's first board meeting, 15-day package, come back for CEQA approval. How do you see that changing if the ARB board delegates to the executive officer the ability to do 15-day changes? I got a little confused there. the process.
Right. So again, I don't see it changing anything as far as the overall approach we use to our hearings and finalizing 15-day changes. We already do delegate to the executive officer to finalize 15-day changes under our current system. Typically not for the projects that involve a full environmental analysis, but that's done, for example, for projects that involve a no impacts environmental analysis or exemption. So again, the intent was just to clearly write down what the existing process is.
Okay, that's helpful. And some of the other pieces of the puzzle, which I sounds like you're going to put in there, is when notices would come out, when they would close, how much lead time ARB would be giving stakeholders, calendar days, working days, all that kind of stuff will be in sort of laid out. Is that?
Yeah, right. So we would be tracking general CEQA requirements for how that works, which we already have been doing as well. It's just not in our CRP currently because it's such a short document and it doesn't get to the level of detail about timing for filing notices and other public noticing and things like that. So the intent would be to flesh that out more consistent with generally applicable CEQA principles.
Great, thank you.
Sure. Yeah.
So are the proposed regulations just limited to the CRP and the 60005 through 08 sections, or is it the entire set of regulations?
It's just to the CRP. That's about the area that we'd be looking to modify. I'm not sure exactly what the final section numbers would be, but those are the sections you identified are the primary CRP provisions that we'd be amending.
Okay. Thanks.
Do we have any questions from the webcast? So I think we had a question about whether the presentation is available to download. It should be. It's on I think it's on the workshop's website. So it's the quickest way for me to find these things is to just Google CARB workshops. And then you'll see as one of the two workshops that appears on there right now is the workshop we're currently having. If you click on the title of that workshop, it will bring you to the presentation as a PDF document, and you can just download that. Okay, unless anyone has anything further, I think that will conclude our workshop. Last call for any questions. Well, thank you all for joining us today. We appreciate it, and we look forward to moving forward with this process with you.